I have been sitting on this bench for 43 years, and in all that time, very few cases have stayed with me quite the way this one has. I want to tell you exactly what happened in my courtroom that day, because I think people need to understand how a case like this actually unfolds once it walks through those doors, not the version you see clipped into 30 seconds online, stripped of context, stripped of everything that actually matters. The whole thing, start to finish, the way I lived it from behind that bench, watching every second of it play out in real time. His name was Bryce Thomas. By the time he stood before me, he had already pled guilty to 4 separate felonies: 2 counts of possessing a prohibited weapon, 1 count of stealing a firearm, and 1 count, reduced down from something far darker, of indecency with a child by exposure. There was no plea deal on his sentence. That decision rested entirely on my shoulders and mine alone. No agreement to hide behind. No number already settled between attorneys before he ever walked into my courtroom that morning. Whatever happened to this young man's future was going to happen because I decided it in front of everyone, on the record, with my name attached to every word of it. I want you to understand something about how I run my courtroom before I go any further. I do not take these decisions lightly. I have sat on this bench for 43 years, and in that time I have sentenced thousands of people. Some I remember clearly, most blur together after enough time passes, but this case, I remember every single detail of it because of how it unfolded, piece by piece, layer by layer, until the full picture finally came into view. Before I said a single word about punishment, I made absolutely sure the record in front of me was airtight. I had read the pre-sentence report myself, cover to cover, the night before, sitting at my kitchen table long after most reasonable people had gone to bed. But then I discovered something else waiting on my desk that morning, something I had genuinely never encountered before in over 4 decades of doing this job. The thickest stack of jail incident reports I had ever seen attached to a single defendant. 35 pages just from his time behind bars awaiting sentencing, 35 pages of write-ups, infractions, incidents, behavior reports, disciplinary actions, all stacked together into one packet thick enough that it nearly needed its own binder. I turned to the prosecution table and asked them outright if they had actually read every single page of it. They told me yes. It had taken an entire evening to get through it all. I remember thinking to myself in that moment, an entire evening, just to read about how one teenage boy behaved inside a county jail while waiting for his own sentencing. That alone should tell you something about where this case was headed before we even got to the underlying facts of the crime itself. I also confirmed there was a state sentencing memorandum filed in this case, and I asked his attorney directly whether he had received it and had the opportunity to actually review it. He confirmed that he had. I asked if there were any objections, corrections, or additions anyone wanted to raise about the report sitting in front of me. None were raised, so I told his attorney he could proceed. His attorney rose first, and I want to give him credit. He tried his very best to soften the picture sitting in front of me that day. He called Bryce a young kid who had jumped off a cliff in a very short span of time and landed himself in more trouble than he could possibly climb back out of on his own. He reminded me that the stolen weapons taken directly from law enforcement vehicles, had at least been recovered, returned to his office on a specific date in early January, then handed back to the department itself. He wanted that fact firmly placed on the record. He wanted me to understand those particular guns were now off the street, out of circulation, no longer sitting somewhere dangerous in the wrong hands waiting to be used. Before I keep walking you through this, if you have not already hit that subscribe button, now is a good time, because I have a lot more courtroom stories like this one that I think people genuinely need to hear, the real version, not the watered-down version. Then came his attorney's actual request, and it was, by his own description, an open one. No specific number attached to it. He floated the idea of placing Bryce on probation for a period of 10 years, just to see how he might handle real responsibility once he was finally out in the world again. Or alternatively, sending him to state jail on one of the lesser charges, with probation stacked directly on top of that for the indecency case specifically, so there would be some lasting form of accountability once he eventually walked free. He explained that these were third-degree felonies, which gave me a fair amount of room to work with as the sentencing judge. He mentioned that Bryce himself wanted to address me directly about those incident reports we had all just spent an evening reading through, that he wasn't trying to make light of any of it, that he understood, at least according to his own attorney, the gravity of what was being weighed against him that day. So I gave the young man the floor myself, and what came out of his mouth nearly took the wind out of the entire room. He told me he was just young and dumb, that being locked up at such a young age meant he didn't fully grasp what he was doing, which was apparently his entire explanation for why those write-ups kept piling higher and higher with every passing week he sat in that jail. I did not let that sit for even a second. I told him plainly, looking directly at him from up on this bench, that growing up means learning from your mistakes, not repeating the same ones again and again while you sit waiting for sentencing. I told him that racking up write-up after write-up does not earn you the excuse of being young and dumb forever. There comes a point, and he had clearly passed it long before that morning, where that excuse simply runs dry and stops meaning anything at all. And then I told him something I rarely say so bluntly from this bench, but I meant every single word of it when I said it. Our jail cannot wait for him to leave, cannot wait to see him gone. Then the prosecutor rose, and he made clear right away that he intended to keep his comments brief, since he had already laid out his position clearly in the written sentencing memorandum he had filed. But he wanted the entire room's attention pulled away from jailhouse behavior for a moment and refocused squarely onto the actual crime that had landed this young man in front of me in the first place. I agreed with him on that. Stealing out of cop cars was the real story here, not the write-ups. He laid it out piece by piece, methodically, the way good prosecutors do when they want a judge to feel the full weight of something. Bryce had broken into not one but two separate patrol vehicles, marked units, belonging to working police officers out doing their jobs in this community. He had stolen weapons directly from the very people sworn to protect the public day and night without complaint. There was a detective sitting in my courtroom that morning, ready and willing to walk through every detail of the investigation firsthand if I wanted to hear it directly from him rather than secondhand through a memorandum. The prosecutor did not hold back his own opinion either, and he made that clear from the start. He told me the sheer audacity required to rob a marked police car told this court everything it needed to know about exactly who this young man really was, underneath all the talk of being young and dumb that we had just listened to moments earlier. If you are finding this story as difficult to sit through as I found it sitting on that bench, go ahead and subscribe now, because the details only get heavier from here, and I think you should hear all of it. And then it got worse, because it always does in cases like this one. The evidence laid out on that table in front of me suggested Bryce may have been tied to an entire series of other car burglaries beyond just these two incidents alone. Other vehicles, other thefts, a pattern stretching well beyond what had originally brought him into my courtroom. One of the stolen weapons had been illegally fitted with what is called a Glock switch, a small device that converts a standard semi-automatic handgun into a fully automatic weapon capable of firing far faster and far more dangerously than any civilian in this state is legally permitted to possess under any circumstance. He had not acted alone in any of this either. He had been conspiring with another teenager, just 16 years old, planning, executing, sharing in whatever came next between the two of them. There was a photograph attached directly to the sentencing memorandum laying out exactly what these two boys had assembled together, weapon by weapon, piece by piece. This was not a simple theft charge sitting in front of me that day. This was, in the prosecutor's own chosen words, nothing less than an arsenal. He asked me to imagine, just for one moment,